Hello everyone. So we finished the schools of thought or jurisprudence aspect of your chapter sources of law. Now we're coming into the sources of Indian law. And our sources of Indian law can be governed into two parts, our primary sources and our secondary sources. So when we have our primary sources, we look at those sources which come directly from the authority which has the ability to pass laws and the subsequent interpretations of the same. Whereas secondary sources are those sources which are applicable only in the case where primary sources are not available, or in the case where we do not have any existing law but we have a certain problem. How exactly will we actually interpret the same? So if you have to look at the sources of Indian law, it comes from a variety of sources, but primarily you need to understand that the Indian law comes purely from legislation passed by our legislature, and our secondary sources comes from other sources apart from that found within India itself. Okay. So let's look at our first primary sources. Our primary sources consists of customs, statutes and legislations, judicial precedents and personal laws. Whereas our secondary sources are the sources of English law and the concept of justice, equity and good conscience. Okay. So let's come down to our primary sources of law. The first primary source of law I will call as your statutes and legislation. Now a small recap. We have the legislature, we have the judiciary, and then we have the executive. The purpose of these three bodies of government, one is to make the laws, the judiciary helps to interpret law, and the executive implements the law. This is how the bodies of government work in our country. So the primary lawmaking body is actually the legislature. The legislature creates laws, or the legislature consists of the parliament or even the state legislature. We have the parliament making laws for the entire country, whereas the state legislature makes laws for our respective states. But sometimes it is not just the legislature which is capable of making the law, but the legislature may end up delegating this authority to a third person or some other person. We'll call this as the ability to delegate to certain other authorities. Now, who is this authority? Sometimes the legislature may pass on the lawmaking power to any body or to any other form of government, whether it is state government or local government or the local authorities. So let's look at an example for this purpose. The Companies Act of 2013 is passed by Parliament. However, all the rules under Companies Act are actually passed by the Ministry of Corporate Affairs, in the sense that the main law was passed by the Parliament, but then the Parliament is not the one who oversees the daily implementation of this law. Who can oversee that daily implementation of the law? We see that the Ministry of Corporate Affairs can be charged with the purpose of daily implementation. And so what happens over here is we can see that laws or statutes which are passed by Parliament or state legislature form a primary source of law. But it is not just the legislature who is capable of making laws, but rather they can sometimes delegate that authority to some other authority. So on the basis of this concept, let's come back to what exactly is statutory law. Statutory law has to be distinguished from customs or usage. Why am I saying this? I am saying this because there are two types of laws in our country, or generally followed by us. We call that as jus scriptum, written law, or jus non scriptum, which we call as unwritten law. If you look at jus non scriptum only, we see as customs. That is a series of actions which have been practiced over a period of time that has been followed by many people, otherwise known as customary law. And then the other thing is known as written law, which is what we call as our statute and legislation. So this statute or legislation is created by an act of parliament or state legislature, and on the basis of this we will come down to the distinction between our supreme legislation and our delegated legislation. So what exactly is the supreme legislation? Supreme legislation is that which proceeds from the sovereign power of the state or which derives its power directly from the constitution. So therefore, what is the sovereign power? We saw that the sovereign power is the highest power in the state and which derives its power from the directly from the constitution. That is, the constitution being the grand norm in our country or being the highest, most superior law in our country, authorizes a certain body to do a certain activity. Say for example, the Constitution of India authorizes the President of India to pass something known as an ordinance, or the Constitution of India authorizes the creation of a GST council and to do such activities under the law. So this is what we call as a supreme authority, an authority which gets its power directly from the constitution. And when the supreme authority, or in other words the sovereign authority, passes a law, we call that as a supreme legislation. Okay. Now supreme legislation cannot ever be amended, repealed, annulled or controlled by anyone other than the legislature. So apart from parliament and state legislature, nobody else is allowed to change or even repeal any kind of laws. And as you can see over here, the Parliament of India possesses the power of supreme legislation. So then what exactly is subordinate legislation? Any legislation which is being delegated to another authority is known as a subordinate legislation. So we can say that the subordinate legislation is that law which proceeds from the authority other than the sovereign authority. It is entirely dependent on the sovereign authority for its existence and validity. And for an example, we can see that the legislature has been given the power, legislative powers have been given to the judiciary as well as the executive. Such rules are known as delegated legislation or subordinate legislation. So like I just clearly said, the Parliament has given or delegated the authority to the Ministry of Corporate Affairs to pass rules under the Companies Act of 2013. Okay, so this is what we call as supreme legislation and subordinate legislation, and the difference between jus scriptum and jus non scriptum. The next is the concept of judicial precedence, or otherwise also known as judge-made law. Now, we've already established that it is the legislature that makes laws for the people, but judge-made law is merely an interpretation of an already existing law, or it is and the activity of providing some kind of a guidance so as to establish a certain set of principles that everyone can follow over a period of time. Okay. So what exactly are judicial precedents? It means the guidance or authority of past decisions for the future cases. Those rules or principles which lay down a new principle or rule is known as a judicial precedent. So what exactly is a judicial precedent? We'll first try to understand it from the concept of the doctrine of stare decisis. What does the doctrine of stare decisis say? It says that adhere to the decision and do not unsettle things which are already established. The problem arises with respect to the number of judges giving multiple decisions across the entire country. Now, each judge may be interpreting the exact same law, but then while one judge interprets a law in a certain way, another judge may interpret the law in a completely different way. This will end up causing more confusion and uncertainty in law. And therefore, for that purpose, what they are saying is that, okay, let the judges follow a certain uniformity or follow certain established principles that brings about uniformity and certainty in law. And so, this concept of doctrine of stare decisis, which says adhere to the decision, follow the decision and do not unsettle things which are established. Okay. So, what exactly do they mean by a precedent? A precedent consists of the following factors. The first one is known as ratio decidendi. The ratio decidendi is the final decision of the judge after looking into the facts, the laws, the arguments, the evidence presented by the parties. And then the final determination or the final decision of the judge is only called the ratio decidendi. So, what exactly does Professor Goodhart say? He says that ratio decidendi is nothing more than the decision based on the material facts of the case. And since this is involving all the facts, the arguments, the laws, the evidence presented, etc., they are saying that the decision that comes as a result of it is only the part of the decision which is to be carried forward as a precedent. Then the second part of a judgment is known as obiter dicta. While passing or pronouncing the judgment, a judge may choose to give his personal opinion, and this personal opinion has nothing more than a persuasive value, in the sense that it is not binding on the judges to follow, but rather the judges can choose to follow it at a later point in time. So, what is the difference between ratio decidendi and obiter dicta? Are they given at two separate points in time? The answer is no. Rather, ratio decidendi and obiter dicta are given at the time of presenting the judgment itself or the final decision of the court. However, in line with giving the judgment, the court may pass a personal opinion. It may say that it is of my opinion that this should be done, or this is of my opinion that this should not have been done. Now, personal opinions have no place, or they do not have that much of an importance when it comes to following a precedent. And so, they only have persuasive value and is not to be followed as a precedent. So, amongst ratio decidendi and obiter dicta, it can clearly be said that the ratio is the one that is to be taken forward as a precedent in line with the doctrine of stare decisis. So, what are the different types of precedents that we can see? The very first one is known as your original precedent. An original precedent is one which creates a new point in law or a new interpretation of the law. So, it must be understood that while the legislature passes laws, it is the judiciary that is tasked with interpreting these laws. There might be some clarifications or confusions that may come up in line with interpreting a law. And so, when a court ends up giving a new position in law or a new interpretation in law, we will call that as an original precedent. A declaratory precedent is one which merely reiterates the original precedent, because the concept of precedent works in such a way wherein the lower courts have to follow the decisions of the higher court. There is no choice given over here, because this is how the rule of law is implemented in our country. When the Supreme Court gives a decision, it is compulsorily followed by all the lower courts, that is the high courts of each state and the criminal as well as civil courts. If a high court gives a decision, it is to be followed by all the criminal and civil courts. However, if a criminal law court gives a decision, then the Supreme Court is not bound to follow it, because the power flows from top to bottom. And so, we can say that when a high court is giving a decision, it may consider if the Supreme Court has already given a decision on the same, if it has already given an original precedent on the same, and it will simply repeat what the Supreme Court has already said. So, we can see that a declaratory precedent is one which is merely the application of an already existing rule of law. Okay. Now, in case of a declaratory precedent, the rule is applied because it's already a law, in the sense that the original precedent has become judge-made law, and therefore it is compulsorily to be followed by everyone else. Persuasive precedents are applicable only in the following cases. Or what are persuasive precedents? That is, they merely have persuasive value, and the judges are not obliged to follow it as a law, but they will take it into consideration. So this is not a proper source of law, and obiter dicta only has a persuasive value. Now, one more thing is that a decision of one high court has persuasive value over another high court. This is only the case with respect to decisions given by the high court. Normally, a decision of the Supreme Court is binding on all the courts lower to it. However, there are many high courts in our country, one in each state, a minimum of. And each high court, a decision given by each high court may be influential or persuasive on another high court. Obiter dicta is not binding as a precedent, but rather it has persuasive value. Absolutely authoritative precedents. An absolutely authoritative precedent is one which a court must follow, a judge must follow, whether they approve of it or not. So if a court has given a decision, of the Supreme Court has given a decision on the same matter, then they are absolutely bound to follow it, even though the judge may not approve of it. So this brings about a uniformity in law, which even though the judge is not okay with this position in law, he must still apply that principle because the higher court has given a decision on the same. This binding force is absolute in nature, and the judge's discretion is completely excluded. He must still follow the decision even if he believes the law is morally wrong. So this is the principle of doctrine of stare decisis. Adhere to the decision and do not unsettle things which are already established. The last one that we can see is a conditionally authoritative precedent. Unlike the absolutely authoritative precedent, a conditionally authoritative precedent can be disregarded in certain circumstances. Okay? Ideally, this should have been absolutely authoritative, but if the court has disregarded a decision contrary to law or reason, then we can say that that decision need not be followed. And this is a very rare case scenario when a precedent has not been followed by a court of law, or it is disregarded in certain circumstances. So I can say that conditionally authoritative precedent is the exception to the rule of absolutely authoritative precedent. And so let's recap what the types of precedents are. We have original, which creates a new rule or law. Declaratory precedent merely declares the already existing rule of law. Persuasive precedent is one which has persuasive value. It is not a legal source of law, and an obiter dicta given in a judgment is not to be taken as a legal source of law. All precedents have to be absolutely authoritative, that is, it must be followed regardless of the judge's opinion on it. And conditionally authoritative precedents are an exception to the previous rule, in the sense that if a decision was given contrary to law or reason, then we can say that that decision was a wrong one, and that court is not bound to follow that as a precedent, and it can be disregarded in certain circumstances. So this is only our case in terms of our precedents. The next one that we have are customs or customary law. Now, when we look at customs are a series of actions or certain activities that people have done over a period of time that they found convenient or they found efficient in the manner of doing. And over time, it has been implemented so many times, or this has been done in a certain way that it by itself has become a law. So if you see customs, we have many customs in terms of trade. We have customs in terms of marriage, over possession of property, passing on of property, etc. So if you see, in a way, customs have molded many forms of law in various countries, and in India more specifically, we have been guided by the existence of customs. Now, when we look at customs, customs can be of multiple types. There are customs with sanction, without sanction. The customs without sanction can be further classified as legal or conventional. Legal customs can be further classified into local and general, and local customs can be further classified into geographical and personal customs. So let's break down what exactly each of them are. The first classification is customs without sanction and with sanction. So the customs which are having sanction is essentially those customs which are enforced by the state, and it is these customs which are further divided into legal customs and conventional customs. So let's try to understand what legal customs are. Legal customs, as the word says, are those customs which have the legally binding rule of law. They are normally enforced by the courts of law and have become part of the law of the land. Whereas conventional customs are also those customs which are simply binding due to a certain practice between two parties or binding due to an agreement between parties, in the sense that they are known as usages and do not have any legal authority which can be independently possessed by them. So, in terms of understanding what conventional customs are, it is simply understood in this way. When two persons come together into an agreement, then they are bound by those rules and not everyone else. So before a court actually treats a conventional custom in a contract, it must be shown that the convention is clearly established and fully known to the contracting parties. There is no fixed period for which a convention must be observed before it is recognized as binding. And the convention cannot alter the general law of the land, and it must be reasonable in nature. Why are we linking up conventional customs and contract? Because normally wherever there is an agreement which is binding on parties, it gives effect to a contract if it falls under all the essential elements of a contract law. So before we can treat a custom as a contract, the court must look at these factors before implementing the same. Now, legal customs itself are further subdivided into two parts, that is geographical customs and personal customs. Legal customs is further divided into local customs and general customs. Local is basically those customs followed by a definite locality and are a source of law only for that place, and such communities can take their customs with them wherever they go. And local customs are further divided into geographical and personal customs, whereas general customs are those which prevail throughout the country and constitute as one of the sources of law in the land. Okay, so this is how we see customs with respect to a source of law in our country. Now, before an activity becomes a valid custom, we have to see whether it falls under these following requisites before it can be called one. What are those requisites of a valid custom? First and foremost, it must be immemorial. It must be ancient. It must have been followed for such a long time that there is no question of its implementation. The custom must be very certain. There must be no uncertainty around it. It must not be vague or ambiguous. Third, it must be reasonable in nature. Any unreasonable customs or those customs which are opposing our justice, equity and good conscience cannot be implemented as a custom. Customs must be followed. You cannot choose to disregard a custom and still gain the benefit of the custom. No, it must be observed uninterrupted from the ancient times. It must conform with the existing law and public morality, in the sense that if if there is a custom which allows the practice of stealing, then that custom cannot be protected by law, because the action of stealing is forbidden by legislation or forbidden in accordance with our morality and public policy. Every person to whom that custom applies must be of general agreement that this is the custom and this is how it should be followed. A custom cannot be followed only by one person and not everyone else. Say amongst the Hindu community, if a custom is followed by the Hindus, then all the Hindus must follow it as a general rule. Or if we are talking about trade practices, then everyone in that trade, say insurance, must follow it as a rule, and not just any one company or any one person. The custom must be peaceably enjoyed, without any dispute, without any questions as to whether it is a valid custom or not. And it must be consistently practiced, in the sense that it must be compulsorily observed and there must be a consistency to the practice. If there is any conflict between this custom and anything else, then that is subjected to its invalidity. So, the requisites of a valid custom are: it has to be immemorial, it must be certain, must be reasonable, compulsorily observed, conformity with law, unanimity of opinion, peaceable enjoyment, and consistency. We come to the last primary source of Indian law, and those are our personal laws. Now, personal laws are also a type of statute and legislation, but then personal laws are applicable on the basis of your religion. For the purpose of our laws, we actually classify our religions into three main religions. We call them as the Hindus, the Christian, and the Muslims, or the Islamic religion. Now, why do we categorize all these three? Why do we categorize in these three, even though we know that there are many more religions? From the view of the law, it is easier to classify multiple religions under the Hindu law, because many of our customs and practices are similar in nature. Whereas Christians follow a slightly different practice, and therefore they are governed by their personal laws, and the Islamic community is governed by their specific laws. So we look at what are the sources of both Hindu and Muslim laws as part of your portions. When we look at Hindu law, we find it in the Shrutis, the Smritis, and in the Smritis, the codes of Manu, Yajnavalkya, and Narada. These are all ancient teachings which are written down by rishis or gurus who have written various commentaries on the precepts and the teachings of God. And these were considered to be a way of life or certain practices which were to be followed by all the people of the land. So now the question becomes, if you are a Hindu, are you governed by your own law as compared to a Muslim? Now the answer is yes, but then it depends on the subject matter of what you are talking to. Now if a Hindu and a Christian commits murder, then both will be punished the exact same way, regardless of their religion. But the validity of a Hindu marriage will be governed by Hindu personal laws, whereas the validity of a Christian marriage will be governed by the Christian personal laws. So it can be clearly seen that personal laws are applicable in matters relating to inheritance, succession, marriage, adoption, co-partnership, partition of family property, obligations of fathers' debts, guardianship, maintenance, religious and charitable endowments. So our customs govern all of these factors as well as statute law, because these customs have been made into statute law, although as we have seen, these are laws with sanction. If you have to look down at the Islamic code, the personal law of the Mohammedans is largely found in the Holy Quran. The Quran is their main text or their main teachings. However, apart from the Holy Quran, we see that they even follow the sayings of Prophet Muhammad. that is his actions, his words, his way of life at the time of his life on earth, those actions, precepts, sayings, etc. were preserved and handed down by certain authorized persons. These are known as hadis. Third one is ijmas, that is, these actions, these sayings, etc., have been debated, and even the opinions of the Prophet and his disciples have been given down as a form of teaching known as ijmas. And Islamic law believes in qiyas or reasoning by analogy, that is, analytical deductions by comparing the Quran, the hadith, the ijmas, etc. to a particular case. So it's not just the above that applies as a standard rule, but then rather analytical deductions which come as a result of it. And obviously many people would have written commentaries on Mohammedan law or digests on Mohammedan law, and those are also considered to be a source of Mohammedan law. Like Hindus, even Mohammedans are governed by their personal laws with respect to inheritance, will, succession, legacy, marriage, dowry, divorce, gifts, waqfs, guardianship and preemption. So these are the subject matters in which personal law will be applicable. If you see any other aspect, whether it is a criminal offense or even if you look at certain commercial laws, there is no distinction between a person of the Hindu religion and the Christian religion, or between the Christian and the Mohammedan religion or the Islamic religion. Okay. So this forms the basis of our primary sources of Indian law, that is statutes and legislation, precedents, customs and personal laws.